All right. Welcome to the North Carolina Court of Appeals. For those of you who have not been with us for the first argument, we have one argument left. It is 25-321 in Re Russo. Counsel, we do not have a clock, as you may have heard, so you're welcome to take your phones up with you. A clerk over here will show you yellow at 2 minutes and then red at no minutes. Do you plan to ask for rebuttal time?
Are we reserve our balance of time? Wherever we end up with at the end, I'm not sure how much it'll be.
Okay, well, she will then just give you yellow at 2, and if you stop, then we'll stop it there, and then come back for rebuttal.
20 minutes probably.
Okay, so you can just sit down whenever.
For
Okay.
Sorry.
You ready?
I am, Your Honor.
Okay.
If it please the court, my name is Jeremy Knight. My co-counsel, Jim Hickman, and I represent the petitioner appellant, in this case, Mr. Devin Anthony Russo. In this dispute over the administration, or we might say non-administration, of the estate of Devin's grandfather, the late Leonard A. Russo, and the trust contained in his will, under which Devin is also a beneficiary, along with late Mr. Russo's second wife. As I said, this is a case of an estate administration and trust administration that never started until this case was filed some 5 years after Leonard Russo passed in the summer of 2018. Devin brought his verified petitions under his grandfather's will and testamentary trust based upon specific statutes found within Chapter 28A and 36C of the North Carolina General Statutes, by which we would assert that our state's General Assembly specifically allowed Devin's legal proceedings to go forward. Because the trial court erred, we have asserted, by dismissing Devin's verified petitions under Rule 12C of the North Carolina Rules of Civil Procedure, due to what we believe are errors of statutory construction, we submit the Court of Appeals must reverse based on this trial court's errors on a de novo basis. It is noteworthy in that regard, Your Honors, that the appealed order does not expressly state its reasoning. Even so, the final order which is appealed, which I would direct the court to at page 127 to 129 of the record on appeal, erred by determining the respondents had shown that there was no material issue of fact that existed such that they were entitled to judgment as a matter of law. With the court's leave, I would like to begin by addressing what we believe are the most important statutory bases of Devin's petitions, which the order below ignored. First, I will point the court to 28A-5-1, subparagraph B, Roman numeral small 2, which allows any party interested in an estate, such as Devin in this case, to petition the probate court where a will has been admitted to probate, in this case in Scotland County, to determine whether an executor named in that will has implicitly renounced the right to serve in that will after they have delayed after the admission to probate, the certificate of probate, in other words, by as little as 30 days. This statute proves that our General Assembly understood and greatly valued, as a matter of public policy, avoiding undue delays in the beginning and hence eventually the end and termination of an administration of a decedent's estate under a will.
So we have a certificate of probate here?
We do, Your Honor. I would point the court there to page 17 of the record on appeal, and that actually was entered by my notes on April 23rd, 2022.
Okay.
So that's the date from which the statute we would assert measures whether Grace Russo waived her right by waiting at least 30 days to become the administrator. It was noteworthy, Your Honor, that in fact, if we look at that, her application for letters was only filed on March 17th, 2023, and I can point the court there if you'd like to review that to pages 18 through 19 of the record on appeal. Again, some 16 months after the certificate of probate was entered. And moreover, I think it's noteworthy, Your Honor, in the grand scheme of things, to look at the fact that at that point, Devin Russo's grandfather, Leonard, had been dead for over 5 years, since March 15th, 2018, as reflected on the death certificate, Your Honor, which is found on page 13 of our record on appeal.
Can you explain to me the difference between the 4/23/2018 date on that certificate of probate and the file date, which is 2022?
Yeah, that's something else I sort of wondered about the entire case, really. I think there's a couple different options. One is it may have been an error. It may have been something that was missed at some point. It's hard to know. There's not really a
Which way, the 2018 or the 2022?
Well, I would say that I don't know. That wasn't really explored. We didn't have any depositions or discovery of the clerk's office other than looking at the bare record. But I say the end point, Your Honor, becomes that even if we assume that later date, then that would suggest, Your Honor, that in fact, at a minimum, again, it had been 16 months. Or it may have been, if this was actually in some fashion submitted along with, could have been, typically you would not expect a certificate of probate, in my experience, Your Honor, to be issued simply based on the filing of the death certificate and the will itself and the basis of the year's allowance is found on page 14 through 15, basically a month after Devin's grandfather died. And I think if you give Grace Russo the benefit of the doubt, she had waited several years to file for letters. And then again, we still have a minimum of 16 months from the date, that perhaps later date, if that's the correct date, of certificate of probate in 2022. And Devin's eventual filing of his petitions in July of 2023. So the minimum point is at least 16 months. And I was going to point to the court, obviously a time window during which one might wait is not the same in terms of a public policy matter as the length of time allowed before one must file a lawsuit not be barred by the statute of limitations, such as, for example, a contract breach in North Carolina or a personal injury claim negligence case has to be brought within 3 years of the action giving rise to the claim. But at a minimum, we know that the courts should understand that the legislature greatly values, as a matter of public policy, moving along with the decedent's will being probated and then administered, because again, as I said, in that statute I just cited the court, 28-5-1B2, Roman numeral 2 that is, the court then was allowed to petition a month after that certificate of probate was first entered, whichever date it was. Right? If we give the respondent the benefit of the doubt, it's at least 16 months and nothing's been done at that point. He had every right under that statute to file a petition to ask the court, and what the court should have done is have held a fact-finding hearing to determine whether they believed that Grace had, in fact, waived. What they did instead, in error, Judge Collins, is to dismiss that petition out of hand under Rule 12C. Certainly
so
not.
Let me ask, this
proper.
application for probate and letters, was that made after your lawsuit was filed?
I'm sorry?
The application for probate and letters, which is found on page 18.
I believe that's,
Is that filed after your lawsuit was filed?
I have that noted here. I believe that actually Grace Russo's application, but apparently no oath, because there's no oath in the file. There's not a proposed administrator's oath in the file. That appears to be filed based upon the date of March 17, 2023, whereas Devin did file his petitions on July 13, 2023.
Okay, but there was an application filed, but there was no oath taken. So we still, to this date, no letters have been issued.
That's correct. There's actually an unissued letters that I included in the record of appeal that showed that we're going to type Grace's name is typed in, her address is typed in, but it's not signed by the clerk's office. And it would look like that's because there's not an oath submitted along with the application. Whether that's an error on Grace's part, I don't know. But the point is, Your Honor, there's not a sitting appointed administrator when Devin Russo files his appeals through our office.
Okay.
The petition, pardon me, Your Honor. Okay. I think, Your Honor, just for this simple error alone, the court should reverse the 12B6 motion that was granted. And again, I think probably the proper step at that point would be to suggest to the court is to send it back to the probate, to the court in Scotland County for them to determine, after a fact-finding hearing, whether a waiver has happened. The court may feel they can rule that as a matter of law. I won't speak to that. But in any event, this is certainly a reason for reversal.
So if we only reach that issue, do the rest of the issues not need to be decided?
I would say they do, Your Honor, because we do still remain the issue of the testamentary trust. That's a critical part of the case.
Let's get to that and to whether the law firm can be.
Yes, where the law firm entity does not receive a license from the North Carolina Banking Commission to act as a trust company, can that entity, not the lawyer, the law firm entity, can that law firm entity then, unlicensed as a trust company, serve as trustee? I think that's a critical issue that needs to be reached, regardless of the prior issue on whether Grace Russo waived her right to serve. And if I could address that initially, Your Honor, if the court looks at 36C704, part of the trust code in North Carolina, defines when a trusteeship is deemed vacant, and then also gives a order of preference in which a substitute trustee can be brought in. We'll see this is another reason why not only the law firm could not serve as a trustee, but in fact, Devin's petition asking for someone to be appointed, whether himself or a public administrator or other appropriate person, is critical to the court to address today. And A4, so paragraph A4 of that statute states the trusteeship is vacant when a trustee is disqualified or removed. We submitted to the court that the law firm entity, Michael Schmidt, attorney at law PLC, is in fact disqualified under our statutory laws set up by the legislature. Subparagraph C of that same paragraph gives a mandatory statutory order by which a new trustee can be brought in when a trusteeship is vacant. First, a trust agreement can state a backup trustee. It's a very common practice. In fact, best practice I would suggest to the court if you're an estate planning and trust planning attorney. Nothing is designated at all there. So that's
okay. Let's stop for a minute and talk about whether the law firm can be a trustee, because that seems to me the most important part of this. Because we know for sure there was no backup trustee named.
Yes, Your Honor.
All right. So explain to me why a law firm cannot be a trustee when the state bar regulates lawyers, correct? And we're concerned about regulation.
Correct. When you're practicing law,
okay.
And I'll be happy to turn to that issue now, Your Honor. And this is, I think, appears to be the best we can tell an issue of first impression under the statute in North Carolina. And I think first I'll note to the court that it's important to note that the Banking Commission agrees that the law firm entity being unlicensed as a trust company cannot serve. I think that's the bottom line point in this point, Your Honor.
Right. And so we have an amicus brief solely on that issue, correct?
Pardon?
We have an amicus brief solely on that issue.
Your Honor. We do, Your Honor, specifically, yes. I would say initially that first, I think it's important to note that the law firm entity, and I would suggest all respondents eventually hang their hats on a mistaken reading of General Statute 53-304, and particularly in regards to subparagraph 2. The overall statute, Your Honor, gives a laundry list of types of licensed business entities in North Carolina which can carry out some trust-like functions due to the fact that they're actually regulated as part of the internal part of that practice, different types of practices, not just law practices, I'll note, as part of their business without requiring a banking commission license as a trust company. And again, I'll point to subparagraph 2, direct quote, rendering legal services in a manner authorized by the North Carolina State Bar, to which Your Honor was referring, I believe. And I would, in fact, draw the court's close attention to RPC 82 of the North Carolina State Bar's adopted ethics opinion, which actually is cited helpfully in footnote 1 on page 7 of the respondent's brief. And this year, I think it's really important to note the actual title of that opinion. It states, the lawyer, not the law firm, not the law firm entity, the lawyer, a human being licensed to practice law in North Carolina as trustee. Each and every example within that opinion deals with an individual lawyer, a human being, not a law firm entity, serving as a trustee or substitute trustee in one specific circumstance, a deed of trust, The other examples I would give the court of examples of which might fit within the ambit of what's reflected by an individual lawyer in that context or a law firm would include receiving personal property settlements, personal injury settlements, for example, after a settlement or a trial verdict is rendered before paying medical bills, costs, eventually the client's recovery and the law firm's fee. It might include acting as an escrow agent, for example, in the sale of real property or in the sale of a business entity. It could include the common everyday practice of IALTA funds being used to hold fund be built against the law firm's fees and expenses and such. It also could include receiving physical property until it can be distributed to the right person or entity.
All right, so let me ask a question. It seems to me that we're concerned about oversight, correct?
Yes, Your Honor. That's part of that, but the statute addresses it more deeply than that.
Okay, I guess my question is, if a natural person that has absolutely no experience in banking or trusts or law can be a trustee, how are they regulated?
Your Honor, I would say that they then are one of two things. Either the person creating the will can allow them to be bonded or not bonded, but ultimately a distinction, I think, is a critical one between an entity. Any entity, as we know, has a limitation on its liability. If a law firm has, say, $100,000 in its trust account and the law firm breaches that duty in some fashion, that might be a limitation of the liability and the practical ability to recover. whereas a company that's going to have a degree, an amount of money required to be serving as a trustee, a trust company licensed by the Banking Commission, is going to have a number far exceeding that, Your Honor.
I get that, but I go back to the fact that you could have an individual with absolutely zero assets who can be the trustee, and then there's no ability to recover. So why are we so concerned about oversight?
Because again, because I think the point is that the statute addresses the legislature has not given us the ability to determine what the policy is here, Your Honor. I think the point is that again, it's either an individual, and keep in mind, a trustee is generally going to be someone chosen by the person, the grantor, the settlor, the person creating the trust. Devin, I can create a trust and make Mr. Hickman or counsel here or anyone in the courtroom my trustee. A person doesn't have to have, and again, I think the statutes are quite clear that an individual not serving as a trustee is not authorized to do that by means of being trained as a lawyer, as a banker, a butcher, baker, or candlestick maker. They can do whatever. They don't have to have that type of training, but they do have an unlimited personal liability, and if not waived by the trust instrument itself, they have to be bonded. So there's a protection there for the parties involved. But again, it's quite clear, I think, when we look at that, an individual lawyer as trustee, just as that RPC 82 says, allows, again, the Banking Commission's brief on page 10 cites, I think, quite clearly the fact that, I'm going to quote directly, any competent adult may serve as a trustee regardless of legal planning or admission to the bar. I'd also refer to on page 11 of the Commission's amicus brief, referring to North Carolina General Statute 3261 state, which indicates that an attorney serving as a trustee may receive attorney fees only if the services rendered are distinct from those related to serving as a trustee and are the type that ordinarily requires separate legal counsel, and I wrote the advice of an attorney. So
you're saying you cannot get attorney's fees for being a trustee, correct?
Not unless there's something there that they're doing is actually legal work as opposed to trustee work. That's clear by the statute, correct. And nowhere in the rule of professional conduct, page 12 of the amicus brief, can a law firm as an entity as opposed to an individual human being licensed to practice law serve in this capacity as a trustee. Now, I want to give a little bit more context to 53304 and note what we're looking at here. These are examples by statute from our legislature as to who can serve as a trustee or not, and without having, or an entity can serve as a trustee or not without having to have a banking commission license to do so. So paragraph 1 deals with a person actually working for a trust institution. So if I go out tomorrow and apply to work at a trust institution, or that's where I don't have to have a license for that, and neither would anyone in the room in that regard. So paragraph 4 allows real estate agents to receive in rents or sales proceeds from the sale of real property without, to the degree that's allowed by the North Carolina Real Estate Commission. There's a part of the licensing piece there, Your Honor, the regulation for the individual acting as a real estate agent. So paragraph 6 allows life insurance agents to take in funds and administer and sell an annuity contract pursuant to their license with the North Carolina Department of Insurance without requiring a trust license. Subparagraph 7, to give another example, allows licensed cemeteries to sell pre-needs funeral policies to people who are, not to put it too bluntly, still alive, not dead yet. They don't need to be buried yet, right?
I want to ask one question, because I could definitely see all that list. But my question is, if we've got the appointment of an LLC, Mr. Sack in this case,
or PLLC, yes, Your Honor.
PLLC, can that just be changed to Mr. Sack?
Your Honor, I would say that if the only way I would say no, it should be decided by the trial court below if that was the case, Your Honor. But what I would tell you is this: that the attorney in this case brought an action to try to oust Devin from his remainder interest. I would suggest to the court he actually may have breached his fiduciary duty to Devin Russo as a beneficiary by seeking to invoke the interim clause. I think he would therefore be someone who should not be appointed by the trial court if they actually got to that point. I think that too bad the Devin Russo's petition filed by our office suggests that either Mr. Russo himself or the alternative, the public administrator. I think they could also look, for example, at someone who practices trust and estates law, even outside the county, to get someone who's not connected with the parties. That might be an option.
I guess my question was this. I understand maybe reasons why you wouldn't want Mr. Sack appointed, but as just a matter of, if the PLLC itself cannot be the trustee, but the PLLC and Mr. Sack are almost one and the same, can Mr. Sack
Well,
perform the duties as the attorney?
I would slightly disagree with that. I think that there's a reason why he filed the LLC organizational paperwork, right? It's a separate legal entity. His entity could he be appointed by the trial court? Certainly, I think that we would certainly object to that. But again, they didn't do that. They said the entity has been appointed. The entity is the trustee. They're wrong on the statutory basis, Your Honor. That needs to be reversed and corrected. Again, by the argument that the parties make on the other side, Your Honor, in theory, not only could any law firm entity in this state serve as a trustee of a trust, a cemetery could serve as a trustee of a multi-generational dynasty irrevocable trust. That would be possible by their argument. I think it would be a ludicrous outcome to have any of these entities, whether a real estate brokerage or a CPA firm or a cemetery company serving as a trustee. I don't think that's what the legislature intended by 53-303, but that would be required, be allowed by their arguments, internal logic. For these reasons, Your Honor, we think that it's quite clear. I do want to turn a little bit more further in depth and actually looking at the question of what type of entities does our statutes set out by the legislature actually allow to serve as a trust entity, to serve as a trustee. And then from there, we can look at 53-303A. Type of entities allowed to serve as, to engage in trust business. A state trust company, not a state trust company, it's a law firm, PLLC. A state bank, again, not a state bank in this case. A state savings association. We obviously don't have a state savings association. Neither do we have a national bank having its principal office within the state of North Carolina, nor is it otherwise authorized under 53-331B2, in which deals with a state trust company in general terms, Your Honor. Again, a law firm entity is not a licensed trust company. It does not receive a license from the State Banking Commission in order to serve as a trust company. Had they sought to do so, I'm not here to gainsay whether it could be approved or not, but the point is by statute, that's what would have been required for any law firm.
So an attorney,
one person law firm to international law firms that might have partners in 5 continents, right?
Would a sole practitioner be?
Yes, that's our understanding, at least in the record. And I think that's what's actually argued in brief by the respondents, Your Honor. But again, the point is it doesn't really matter whether it's a one-person law firm or a law firm that has partners in 5 continents and does all sorts of things, and others might do, those large law firms do, unless that entity has applied to the North Carolina State Banking Commission and receive a license from that entity that has to be renewed yearly to serve as a trust entity and provide trust services. That law firm cannot do it. Doesn't matter which law firm we're talking about, the biggest one in the world or the smallest one, the most humble local law firm, Your Honor.
But an individual in that law firm can, as an individual attorney, and then it has the law firm's resources behind it. That's your argument?
Correct. Any individual lawyer could do that if they want to. If the client wants to appoint his lawyer or her lawyer as a trustee, they can do that. All right, that can happen.
So it's your argument here, because it's a PLLC, this needs to go back to the trial court then to determine if there is a trustee?
I think the way the court should rule, if I may suggest at this point from the Court of Appeals at this point, I think the correct ruling we believe would be to find that the trusteeship is vacant due to the fact that the PLLC entity cannot serve by statute due to its lack of licensure of the trust company, should be sent back to the court to hold a hearing to determine, the court to determine at that point who would be the appropriate substitute trustee. If Mr. Schmidt individually wanted that role, we would certainly object to it, I think, at that point, Your Honor, given the fact that he's already displayed an animus and a chart to unseat Devin as a residuary beneficiary of his grandfather's trust. We think he, in fact, we didn't been inserted at court at this point, but it might be seen as a breach of fiduciary duty to have done so. Certainly the other beneficiary could have argued that, I suppose, but only other innocent party in the case, Your Honor. But certainly I don't think that we would think it's a good idea. Did the trial court do it? Certainly. They could appoint pretty much anyone who's a competent adult able to be bonded in that context, Your Honor. But ultimately, again, due to this law firm entity not holding a trust license from the North Carolina Trust Banking Commission, the trust, it was improperly named. It should be deemed to be vacant, and the court should make clear, I think, as a matter of the development of our state's appellate law, first case to decide this issue. And therefore, there's one more reason that Devin's petition should not have been dismissed. And if I could, I'd also like to just mention this very briefly, if I could. I'm not sure how much time I have left.
7 minutes.
Thank you. I'll be real briefly. Some of the contentions from the opposing parties as to why they thought that Devin's petitions were a challenge to the will and trust, and therefore he should have been deemed to have waived his rights under the interim clause. I would direct the court initially to Article Roman numeral 4 of Leonard Russo's will, which I would tell the court is found on page 5 to 6 of the record on appeal. It does provide that Grace Russo received what she received through his will in addition to the house, which is held in trust, specifically the fact that anything that came to Grace says eventually should be, by contract to make a will, should be transferred to Grace by Devin, by Grace's own will. She's still living now, as the court's aware.
Let me ask you this. Was he challenging the will, or was he trying to have this, this will, I guess, enforced the way it was written?
Enforced.
So this wasn't a challenge. It was asking that this estate be closed and that certain things happen according to the will.
Yeah, I think one thing Mr. Russo would definitely like to see was to have someone serviced as executor, or and probably more likely administrator CTA, since we would argue that neither Grace had waived her right by delaying 5 years before she applied. We also think that the law firm entity, again, likewise, cannot serve in that PR role as a backup trustee pursuant to, even though the will says is to be appointed, Your Honor. I think that they should have appointed at that point someone to serve as administrator CTA so the estate could have been carried out, actually gone to close 5 years. This is not a simple, if I may use the phrase, I love you will, where the decedent leaves everything to the spouse.
I guess hypothetically, what would happen if he hadn't filed the petition?
Right, that's right. If this had been a will that's going to be left everything to Grace Russo, period, that's the end of the will, 2-page will, right? 3-page will. That would have been nothing to argue because there would have been no residual beneficiary to Devin Russo, my client. However, given the fact that there's a trust that needs to be funded, there is an estate that needs to be administered. There's also, in certain points, we've asked for clarification from the court as to the meaning. That's where the declaratory judgment comes in, Judge Griffin, asking to determine, to basically give an explanation of the meaning of the Article 4, again on page 5 to 6, and also note Article 5, actually Article 4, the Article 5, paragraph C on Leonard Russo's will, which is found on page 7 of the record on appeal, contemplated that the trust itself might fail or not take effect. Therefore, asking the court in Devin's petition to rule whether that had happened or not. That was, again, contemplated within the means of the will. And that would not have prevented Ms. Russo, by the way, from receiving her benefit of the will. So it was not intended to destroy the will. It was simply just defined as to what had happened. And again, if the will says, in the event that Grace Russo does not make provision to provide that Devin Russo will inherit anything she inherited and has not used for her living during her lifetime, would be then deemed to be turned over to Devin at the point of Grace Russo's death. The will itself would then impose a trust, leaving Grace Russo as a lifetime beneficiary of those assets, obviously able to use them for her needs and living expenses, to state the obvious. This was not the thing. She couldn't access it during her lifetime at all.
The trial court found for you on this. The trial court found for you on this issue, correct?
Pardon?
The trial court found for you on this issue, correct?
They did not. They found for us on almost nothing.
The trial court found that you had that Devin had forfeited.
No, that's a good question. They did not, because they did not find that Devin had challenged the will. That was not ruled on. But again, I think that if you look at it, and because I bring it up in part because the opposing party, the respondent, actually in their brief, their issue was whether or not basically 12B1, my client, which the only way that would happen is if Devin's petitions were actually attempts to destroy the will, to overturn the will, to caveat the will. If that had been the case, then Devin would have lost it under the interim clause, could have lost it if he didn't have a good faith reason to bring it. That's the way the caveat cases work, as the court's aware. There's no attempt to destroy the will. It's not a caveat. Devin has not alleged undue fraudulent execution. Didn't claim his grandfather didn't sign the will. He did not claim his grandfather lacked capacity to make this will and trust. He did not claim undue influence by anyone, including his second wife or anyone else. And no other way, as a matter of law, was Devin's petition at all an attempt to destroy the will, to destroy the trust, to undermine it. It was simply to see it be carried out after, I repeat myself, 5 years of inaction. 5 years of inaction. Only shortly before Devin filed his petition, at which point, obviously, he and his counsel were aware of the pending of this matter, Your Honor. That's when they finally filed the application. 5 years, I would suggest about 5 years, or at least 5 years or so too late. And the last issue I'll just mention real briefly is the issue of Devin's petition for attorney's fees. That was denied. We think this will be reviewed on an abuse of discretion basis rather than de novo. And again, as I mentioned at the offset, the appealed final order does not give the court any basis to understand its stated analysis of rationale. There's no rationale given at all. But the logical conclusion, I think, is that denial drew upon the other areas of law that we've already rehearsed for the court today at some length, and we think for that reason they denied the application for attorney's fees. Devin was simply following what the statute allowed. He should not. The 12B6 should 12C should never been granted. We should have had then a hearing to determine who was the correct trustee, who should be appointed to handle the estate, whether Ms. Russo or someone else. And then we should have moved on from there.
So is it your contention that he is entitled to attorney's fees now, or simply that he's not entitled to not attorney's fees and it should go back and be decided later?
Your Honor, because I think he should have been awarded attorney's fees. I would believe he's entitled to attorney's fees. We believe we had a very good faith basis. It's obviously an abuse of discretion standard. We think that the discretion was abused due to the fact that the judge acted based entirely from front to back on an error of law in terms of not dismissing the petitions under Rule 12C. I think, again, just in closing, that the trusteeship should not be allowed to go to an entity. That should be decided by the court in some fashion because there's no backup. We think that Grace Russo, they should have at least found how the hearing is whether Grace Russo had waived her right or shown herself otherwise to be unsuitable by her 5 years delay. We would argue she did. That someone should have been appointed, whether Devin Russo or a public administrator or some other practitioner who's familiar with estate planning and probate and trust administration, certainly. And we do think certainly his petition for attorney's fees should be granted. We believe that statute is there, we believe, Your Honor, to allow for someone like Devin to bring forward this kind of petition and to ask the court, hey, please notice there's a delay going here, Your Honor. Please take care of that. Please fix this issue. Otherwise, Your Honor, if people like in Devin's position can have themselves kicked out of court under a 12C motion, no one can ever enforce those statutes that our legislature basically they'll be taking a black pen and marking through that so that it's written completely out of our statute books. That's certainly not what the legislature intended. All Devin asked for was a day in court and for the court to decide who should be the executor or administrator CTA, who should be the backup trustee. And Your Honor, that was not done. Justice was not done here. We'd ask the court to reverse and return this issue back to the court for proper decision, Your Honor. Thank you.
Thank you. Fine. Yeah. You do not have any time for rebuttal, just so that you know that.
Good morning, and may it please the court. Stephen Bader from Cranfield Sumner here in Raleigh on behalf of Michael Schmidt and Michael Schmidt, attorney at law at PLLC. This court should affirm judgment on the pleadings for my client because the law does not entitle the petitioner to the relief that he seeks. And I want to start the argument by talking about the only issue that is raised as to my client, and that's the issue of the exception under 53-304. I've gone back through their brief in preparing here this morning and certainly went through it back in the respondents when I drafted my respondents brief several months ago. And arguments 1, 2, and 3 deal with Mr. Schmidt and his PLLC. And all three of those arguments in the petitioner's brief rest on their contention that a PLLC cannot be a trustee. I know the argument here was open this morning with other discussions about timing and things moving along. As to my client, those issues were not briefed. They are not before this court pursuant to Rule of Appellate Procedure 28A. Now, dealing with the single issue that is before this court, it's really, does the Multi-State Trust Institution Act work to preclude Mr. Schmidt's PLLC from acting as trustee in this case? The answer to that question is no, and it turns on the General Assembly's policy decision in paragraph 2 of 53-304. And that says, of course, that a company is not subject to this act if it is rendering legal services in a manner authorized by the North Carolina State Bar.
But wouldn't you agree that rendering legal services and the trustee work is different, and you cannot get attorney's fees for trustee work if it doesn't include attorney work.
I agree with the second part of that question,
Okay.
Your Honor. I think when we look at the definition of practicing law that's provided in Chapter 84 that I cited, it's a broad definition. It says it's performing any legal services, specifically including the preparation or aiding in the preparation of wills, trusts, instruments, reports of trustees. That definition ends with a larger catch-all sentence that says it's not to be construed to limit the definition of the term, but to include other particular acts that follow within that definition. And I think Your Honor has already hit on it this morning. Any trustee work that's done by a law firm is overseen by the state bar. And that to me is really what...
Is it done by the law firm or is it done by the lawyer?
Well, the state bar is going to oversee it either way, whether it is done by an attorney or whether it is done by a law firm or whether in this case it is done by a solo practitioner practicing as a PLLC. And I think when this court looks at this exception, really, I would argue it recognizes three overlapping truths. The first truth is that when people are putting together simple wills and trusts, like in this case, I mean, this is a 9-page document, that they choose the lawyer or that law firm that prepared the instrument to be the trustee. And they do that rather than a family member or an individual that, as Your Honor has pointed out, may not be subject to oversight, or rather than a large financial institution like U.S. Bank, just because of the costs associated with it. The second truth is that lawyers occupy a position of trust in society. People trust their lawyers.
True, but you keep saying lawyers, and lawyers are allowed to do this, and I think that's the difficulty here.
And I guess my response to that, Judge Collins, would be that when you look at 53-304, the General Assembly did not put right into this exception lawyers, individuals, professionals. It used the term company. It said a company, and then it goes on to say does not act as a fiduciary, does not engage in trust business. You have to look at those terms in the context they're used within that act, because of course, quite literally, it could say a company does not act as a fiduciary when it renders legal services. And of course, that's not strictly true. So what the statute is talking about is in fact the acts done by the company. And the definition of company within the statutory scheme at 53-301.12 includes a limited liability company. And of course, a PLLC is a limited liability company that's authorized to practice law under Chapter 55. So when we put the different pieces of the statutory puzzle together, it does recognize that truth that law firms as well are fiduciaries. And that leads to really that third truth that I want to mention, which is that the state bar oversees lawyers, it oversees law firms. For this kind of trustee work, the PLLC is subject to state bar oversight and regulation. And I think to hit on what the record reflects in this case, the trustee in this instance was going to have to confer with Grace Russo, the lifetime beneficiary of the trust, to work with her if the home needed to be sold because her needs had changed to the point where she couldn't maintain it, to find a suitable replacement home, to make sure that any additional monies were used for her lifetime and care, and then that anything left at the conclusion of that, be it the home, be it any money, would then pass on to Devin at the end.
Can we just go back, because we had talked a little bit about it's not being an issue of timing, but nothing happened for a very long time. And your argument is nothing needed to happen. Is that correct? I mean, there was no inventory filed, there were no letters issued. It wasn't open, it wasn't closed, nothing happened.
Well, what the record reflects in this case is that there was really, this was a modest estate. I mean, when the application for a year's allowance was made by Grace Russo, I think within about a month of Mr. Russo's passing, there was almost a $26,000 deficiency. And the pleadings in this case, Grace Russo's response to the complaint, her position is that we didn't want to drive up costs because there was no residual property for this trust. There was nothing to administer. The only thing that may have needed to have been done down the line is if and when this property needed to be sold, there would need to be notices put out to creditors. But other than that, there wasn't even enough money for a yearly allowance, so there was no reason at that point to drive up costs. I don't want to be a broken record. I would at least reiterate that as to the trustee, any argument that that would somehow state a claim to withstand the Rule 12C motion is not before this court in the briefing, but that is what the record in this case reflects. You know, just to kind of close the loop, perhaps on this idea of bar oversight, I don't think there's any disagreement here, at least not that I've seen, that lawyers as individuals are subject to bar oversight. I don't think there's any disagreement that law firms are subject to bar oversight. And when you look at the purpose of the Multi-State Trust Institution Act, it's to regulate trust institutions that engage in this business on a multi-state or an international basis. That is not a North Carolina law firm, certainly not a sole member PLLC. I'll offer what I think is kind of a silly, example here. You could have a law firm that shares office space with another small business, and the law firm knocks on the door and says, we also provide janitorial services. So if at the end of the day you want us to, our partners and our staff will come here and clean your office space, it's whatever it is a week. That kind of a service might be something that's beyond the state bar's oversight. But when we are talking about a trust acting as a trustee and fulfilling the obligations of that written instrument prepared by the law firm, that is rendering legal services within what our general statutes provide and within what the legislature contemplated with this exception.
Why is the amicus brief, why is it so adamant that this is not covered? What is it that they are trying to protect, and what is the policy here?
I think the amicus is probably better situated to answer that question, but I will certainly try. I mean, what they have suggested, I think, as I recall, is that law firms or corporate structures are going to have limited, potentially limited liability for their members. And number one, I'm not sure to what degree that's true in a partnership setting. And in this instance, you have a sole member PLLC. But again, that is not a realized concern because that PLLC is still overseen by the state bar. If the concern is that a law firm acting as a trustee could abscond with trust funds, the bar is going to take care of that. That's what the state bar does. And that's why when the General Assembly enacted this statute, it said we're going to carve out an exception for that. And again, not for individuals, not for professionals, but for companies. That's the term that they elected to use in 53-304 and in carving out those various exceptions. Exceptions that also speak to other professionals that would be involved in this kind of work, including people subject to real estate or companies.
Are the regulations or enforcement of potential violations, are they similar between the bar and the commissioner of banks?
I'm not sure I know the answer to that question, Judge Griffin. I don't know, but I think
could that be why they're so spun up about it, that they feel like they can provide more oversight or something different than what the bar could do?
It could be, but if that's their position, I don't recall seeing that in their brief. I recall seeing what I would call a broad brush concern that because there's limited, in theory, limited liability for members of professional organizations, that could somehow invite concerns for trusts or for the beneficiaries of trusts. But we would go back to, but the state bar still retains that oversight and would still have the ability to impose any kind of appropriate disciplinary measures against the members of that law firm. And I want to make sure that this is clear. There is certainly a strong feeling here by my friend about this case, but this is not a situation where anybody's alleged that my client has done anything wrong. Nobody's saying that he is mismanaging funds or that he is doing what he is not supposed to do with the trust. In fact, when you looked at what the trust instrument says, which we interpret according to its plain language, what Mr. Russo wanted was for his wife to stay in that house until he passed. That's what he wanted. That is very clear. There has never been an argument to the contrary, and that is what has been done in this case. I don't want to belabor points, but I want to make sure I'm helpful to the panel if there's any other questions or concerns about this exception and, again, the sole issue that's been raised here by the appellants.
Yeah, and I just want to, this is really an issue of statutory interpretation and nothing else, correct?
It is. It is. And without belaboring it, that is where we cross-reference Chapter 84, defining the practice of law broadly. That is where we look at Chapter 55, talking about PLLCs and their ability to practice law. And I think at a very fundamental level, it starts with the definition of company in the Multi-State Trust Institution Acts, which includes an LLC. And, you know, I guess I should, make this point as well, which is if the petitioner's position is accepted by this court, this exception is effectively gone. I mean, certainly in a scenario like this, there's no dispute here that what Mr. Schmidt's PLLC was doing was providing legal services to Mr. Russo. It drafted his will. It set up this trust. And Mr. Russo said, you are the person of trust with a fiduciary duty to this trust that I want to administer it. So if that doesn't fit within this exception, I think the exception will effectively be written out of the rule. And that would be contrary to what the legislature said when, again, it chose that specific word company. It said that the company is going to be exempt from this statute. I don't want to belabor this, but I'm just going to hit on the forfeiture issue very, very briefly. You know, the court doesn't need to get there. We can start there and make it easy. That was just an alternate basis in law that we presented strictly as a basis for 12C relief. It wasn't a counterclaim. There wasn't some affirmative action taken against Devin. It was a defense pleaded, which is you can't pursue this. And the reason you can't pursue this, when you look at the declaratory judgment, the very first thing that's requested is a declaratory judgment that this trust has failed. That is an attack on the trust. That's an attack on the will. You know, from there's a request to find that Grace is not the executor, that the PLLC is not the trustee, that letters of administration should be issued to Devin. All of that is an attack on the will and the trust. If there was, again, this is not this case, but if there was a hypothetical situation where a beneficiary of a trust said, I'm not getting the information I need an accounting. There's a way to go about doing that. If the trustee is mismanaged.
Weren't there phone calls here asking for information about what was going on in this case and those answers were not forthcoming, correct?
Yes. I mean, I think there's probably a disagreement between the parties as to what would have been needed to be disclosed, whether they were forthcoming. But I'm more so stating from a legal basis, there's other relief that could be sought versus a direct attack on the trust or the will itself.
But isn't that more of a remedies question? Don't you have the ability to bring this claim? And it's not a will caveat that you didn't get enough under the will. It's that the will isn't being followed. That seems to me ultimately different.
Well, I think it is a remedies question, but then it gets into what Article 3, Section F says, which is if any beneficiary brings a legal proceeding to challenge this will, that would be forfeited. And what our Supreme Court has said on these clauses is that they are enforceable as written, but they're not enforceable when there is a challenge as to whether the decedent had capacity or whether they, in fact, signed it. And so our position is that that's not the challenge that's been made in this case. There's no argument that the will is not genuine. There's no argument that there was a lack of capacity. The argument is that the entire will and the trust should fail, at least as to our client, because of the fact that the PLLC was designated as the trustee. I'll emphasize again, I don't think the court needs to get there. That was an alternate basis in law. But we did brief it, and I did want to make sure I at least mention it, and if there's further questions, that those have been hit on as well.
No, I have a question as far as, so you were asking us to affirm, obviously.
Correct.
But is there a genuine issue of material fact as to who this trustee is if a PLLC cannot be the trustee?
Well, I'm wincing a little bit at your phrase because this was decided at the Rule 12C stage. So it's not a question of whether there's a genuine issue of material fact. It's really a question of what's been pleaded.
Yep.
Now, I think in fairness to your question, Judge Collins, if this court were to say, were to adopt their legal position, then the law would give them relief, in theory. Now, we would say that this is a perfect example of a 12C case. They say the reason he can't be the trustee is because of this statute. We say that is not what the statute says when you look at its language and when you look at the legislative intent, and that's the reason it should be affirmed. It's not a summary judgment ruling where there's a question about issues of material fact.
So it would simply go back and proceedings would continue.
It would, right. I mean, like with any 12C motion, if it were reversed, it would proceed forward with discovery in the ordinary course. And on behalf of my client, Your Honors, I want to thank you for your time here this morning. We do ask that you affirm judgment on the pleadings for my client, Mr. Schmidt, as well as his law firm, the PLLC. Thank you.
Thank you. Thank you both for your arguments. We will take them under advisement. At this point, I would like to adjourn court, and then if the attorneys might be willing to stay for 5 minutes to let the students ask some questions, not about the case or the merits. So would you please adjourn?